Do you have an immigration question? Visit immigrationquestion.com, the easy way to get your immigration question answered from immigration attorneys. Free registration for users and immigration attorneys. And it's available now. For a limited time offer, visit immigrationquestion.com and get your immigration question answered. Immigrationquestion.com is not a law firm or affiliated with the USCIS. It's an interactive platform between users and immigration attorneys.
Hi, everyone, and welcome to this week's episode of our live webinar series, proudly brought to you by immigrationquestion.com, your trusted source for up-to-date immigration news, legal insights, and live conversations with licensed immigration attorneys. My name is Anusuya Mukherjee, and I'll be your host for today's critical session, Detained by ICE, Understanding Your Rights and Immediate Legal Remedies. Getting detained by ICE can be one of the most terrifying experiences for an immigrant and their loved ones. It creates fear, confusion, and chaos, not just for the person in custody, but for their entire family. In those few hours and days, knowing your rights and acting fast can be the difference between freedom and deportation. That's why today's conversation is so important. We're here to walk you through exactly what to do if you or someone you care about gets picked up by ICE, from understanding how ICE detention works to fighting for release and preserving legal options. This webinar is about empowering you with the right information at the right time. We are honored to be joined again by attorney Isadora Velazquez, a board-certified immigration attorney and founder of Isa Law in Miami. Attorney Velazquez has over 15 years of experience and is nationally recognized for her work in removal defense, asylum, and complex family-based immigration. Born in Puerto Rico to a Puerto Rican father and Venezuelan mother, Attorney Velazquez understands these issues on both a personal and professional level. Her advocacy is relentless and her compassion is real. Welcome again, Attorney Velazquez. It's always nice to see you.
Same here. It's always a pleasure to join you guys and get to talk a little bit more about immigration.
Definitely. Before we dive in, just a quick important reminder. Immigration Question is a two-in-one platform that connects users with licensed immigration attorneys. We are not a law firm and we are not affiliated with AILA or USCIS. All legal services are provided independently by attorneys in our network. So, Attorney Velasquez, let's just jump in. I want to start with the basics. When someone is detained by ICE, what typically happens in the first few hours or days, and what should families know about right away?
The main thing that we need to understand is that we don't have the typical rights that we associate with a U.S. citizen, and that is mainly the right to appear before a judge immediately. In fact, what we tend to see is that when individuals are detained by ICE, depending on the detention, if the detention happens at a CBP facility, a Customs and Border Patrol facility, that could be an order of supervision, people who already have deportation orders or cases pending and report themselves and are detained there, they are sometimes held at that facility, maybe for the day, or immediately transferred to the closest detention center to that area. But that doesn't mean they're immediately processed. So when the individual is transferred, they may have a location where they will spend the night and they will call family members. They will always have the right to call a family member and let them know where they are located. But the fact that they're not processed complicates attorneys visiting them and having ability of having the family also visit them or even follow-up conversations. So it's good to understand that although very frustrating, it may take days before a deportation officer actually meets with the person detained, processes them correctly, and allows people to have access to greater phone calls per day. Also allows the attorney to file the necessary motions to get them released if available. Regardless, although it is frustrating to have to wait, and I give the disclaimer so that people understand when they call the attorney and they tell them there's nothing the attorney may say, as I say sometimes, there's nothing I can do right now, it is helpful to contact an immigration attorney right away because people are sometimes transferred to facilities and then transfer somewhere else. Taking action right away, having an attorney file, for example, a motion for bond proceedings right away will allow the individual to have their hearing conducted quickly. Although it may take a couple of weeks, it will be quicker than waiting. And at the same time, it will retain the jurisdiction. It could retain the jurisdiction in that place before anyone is transferred. A good example here in Miami, where I am located, we have some detention centers that have great judges. We don't know if the judges are going to be great in Louisiana or El Paso, where people may be detained. By having an attorney jump in right away before somebody is transferred, I know that I can keep the great judges we have at the Chrome Detention Center hearing the case instead of maybe a new judge that I don't know somewhere else. So that's what to expect, to be very patient and to understand that it may take a while to get a response, but the person will call you to let you know where they are detained once they're settled, and that should happen within 24 hours.
Definitely. Thank you. Another question we get is a lot of people panic when they hear a loved one is in ICE custody, which is understandable. What are the first tips they should take to protect that person, especially if they don't know where they've been taken to?
For anyone who needs to locate somebody, understanding that it may take a couple of hours before you know their exact location after detention, you can Google detainee locator ICE, or actually I would say detainee locator ICE. It will be the first hit. You'll get a detainee locator. It's redundant, but that's actually the name. You can click on that link, and you will have two ways of finding out where your loved one may be located. The first one is through their alien number, and you can put that information in, and it will tell you this person is located at this detention center. The other one, if you don't have the alien number, it will be their name, their country of origin, and their date of birth. That goes to my second main point as to what to do right away to protect the person, the individual might be detained. Keep checking the detainee locator where they might be, and at the same time, try to locate their immigration file. Now we have advised our clients who may be reporting, as I said before, individuals who have to report to ICE, to make sure they have a file readily available with their documents, their immigration documents, those documents that may contain their alien numbers, anything that may have happened in court proceedings, or anything that may have filed with USCIS, have it readily available for somebody to present just in case. Similarly, for people who maybe are not reporting but maybe here out of status, it's good to have your documentation, your passport, how you entered into the country, available for somebody to assist you, so that if you are detained for whatever reason, an attorney can jump in and immediately start working on your case. These are documents that should be readily available. That would be my second tip for anyone, to just look for these documents once somebody's detained, so they can contact an attorney and provide them with something to work on.
Definitely. Thank you. Let's talk about legal remedies. What are the main options for fighting detention or removal, and how can someone pursue release through a bond hearing or custody review?
As you mentioned, the main remedy for anyone who is detained, of course, we want to get out of jail, would be a motion for bond, but understand that not everyone will qualify for bond. For example, recently, we got a new memorandum that reinterprets the law from 1990, letting us know that individuals who entered the U.S. illegally may not qualify for bond. This is a big change from the law since the 90s, since typically people who are already in the U.S. are not considered arriving aliens, and they should qualify for bond. And it will be interesting how this memorandum is actually implemented, because I do foresee there will be a lot of litigation, and maybe even some judges who will say, we can't follow law by memorandum. It needs to be either an executive order or a decision from a judge or an actual law. So it will be interesting how it's implemented, and this was just announced within this week. So we'll see how many individuals who are already here in the U.S. without status, who enter illegally, if they're detained, if we can fight for bond or not. I know that myself and many of my colleagues, we will be filing the bond motions regardless, and we will argue exactly that you can't propose new law by memorandum, that it should be an actual law. So we'll see how that works out. As to other individuals who may not qualify for bond, this will be individuals who already have a removal order, anyone who has a conviction for a controlled substance. There is now a new law called Lake and Riley Act, which means that if you have a warrant out for your arrest, even for simple crimes like petty theft, even if you haven't been convicted, even if you didn't know there was a warrant out, based on the Lake and Riley Act, individuals who do have those warrants don't qualify for a bond. And lastly, the category I mentioned before, arriving aliens. And arriving aliens is anyone who presents themselves at a border port of entry. It could be border or airport, and they're not allowed entry. And then later they seek asylum. Those individuals may be detained, and sadly, they do not qualify for bond. However, the alternative would be to work directly with ICE and request a parole. Parole is permission to enter the U.S., permission to be released from custody. That wouldn't be through a judge, like a motion for bond. It would be with an ICE officer explaining the circumstances and basically begging for parole, which may also have a cost. For individuals with deportation orders, they will need to have a credible fear interview if they're afraid to leave their country, or file a motion to reopen if their case has new evidence or circumstances that may allow for the deportation order to be removed. Until that's resolved, they will not qualify for bond, even if they request parole. So these are the remedies available for release from detention. They're very limited and they change quickly, so it's good to stay up to date and call the attorney right away as soon as somebody's detained to prevent a possible deportation, which may happen quickly.
Definitely. Now, many families don't realize how quickly things move in the cases, right? So, what strategies do you recommend for preserving relief options, especially for someone who may qualify for asylum, cancellation of removal, or adjustment of status?
I kind of hinted in my prior answers, but I hate to sound cliche, but you really need to call an attorney right away to make sure that they jump on the on your remedy that you may qualify for. For example, cancellation of removal, a remedy that you mentioned, typically requires for individuals who don't have status, meaning they're not residents. It will require for them to live in the U.S. for 10 years, and it will require also that they have what we call a qualifying relative, which is that relative who is either a resident or a citizen, and that individual must need you in an extreme and unusual way. To prevent a quick deportation, it's especially if the case is complicated, depending on the circumstances, it's good to file this remedy quickly in court because it's a remedy that is only available in court. But you want to file the best remedy possible. You don't want to have it be just a bare bones application and then make it a little bit more difficult to fight later on in court. So it's good to have records right away. I previously mentioned how it's good to have your immigration records available for somebody else in case of detention. These records should include your children's birth certificates, if you own a deed to your house, what ties do you have to the United States. So it's good to take action. Asylum is even more interesting because there's there may be limitations on when you need to qualify. So if individuals who have already applied need to take action right away to transfer their application to an attorney that can review it and pursue it in case you are detained. Same applies for adjustment of status. Adjustment of status is not just through a family condition, it may be employment. Having those records immediately available to present to a judge is essential to take action and prevent the deportation. Individuals who came here, who have been in the U.S. for less than 2 years, may be subject to something called expedited removal, which is a quick deportation solely because they've been in the U.S. for a very limited amount of time, which is why it's essential to file any remedy with the court quickly before the expedited removal order comes up, because otherwise you'll be trying to not only fight your case, but also try to remove a deportation order. So here, moving quickly, understanding that it may take a couple hours before somebody's processed, but moving quickly is the best way to prevent any immediate deportation or quick deportations, which are happening particularly for people who have been here for less than 2 years or people who already have removal orders.
Definitely. And then communication is also key, right? So, how can family members or advocates communicate with ICE or locate someone who's been detained? I know you mentioned the detainee locator, but what are other ways, where they can, find out about where their loved one is? Because sometimes people get caught in like a traffic light or a stop sign.
Once again, anyone who is detained by immigration will have access to a phone call to our loved one to let them know where they are located. Now, once they have communicated with their family members to let them know where they are located, and that this will also apply if they're transferred from that location somewhere else, they will have access to a phone call to let them know about the transfer. But once they're established in a detention center, lately we've been having serious issues with their phone communication with their relatives. Individuals, when they are detained, they receive a PIN number in which their family members or friends, relatives can send money to that PIN number, and then they can use to place phone calls. Phone calls from detention centers are not free, not even to your attorney or to your loved ones. So what we noticed, which is a big problem, is that without meeting with the deportation officer, as I mentioned at the beginning, people don't have access to that PIN number, and that sadly in many of the federal detention centers, the PIN numbers are not working. So my detainees and clients have been very creative in trying to join forces, and maybe one be friends with the other, exchange items in commissary in exchange for phone numbers to be able to call people for those who have working PIN numbers. It's very unfair. We attorneys have been fighting with the deportation officers to make sure they do their job, and they've been blaming it on technological issues. And we've noticed this is a problem not just in South Florida where I'm located, everywhere. My clients in Louisiana, Texas are also having the issue with not being able to place these phone calls to their loved ones. And sadly, relatives cannot call in to speak with a detainee. You can call into the detention center to know if the person's there, but you won't have the access to speak with them. So they have to call us. Now for attorneys, which is why it's so important, and take it from I'm an attorney myself, so you may take it with a grain of salt, but I do encourage people to speak with attorneys because we do have access to communication that the regular public, family members, and friends may not have. For example, attorneys like myself, when we are representing people in other detention centers that may be far from me, Louisiana, Texas is an example, we have access to the deportation officers directly, and we can request a virtual visit, which makes things better and allows us to communicate with our clients. It also allows us to relay messages for those clients who haven't been able to communicate with their family members. So that's another incentive to have an attorney assist you, that attorneys do have additional resources to communicate with clients when they're detained that sadly are not available to the public in general.
Definitely. Thank you so much, Attorney Velazquez. That's been enlightening, and I know our audience must really find it enlightening. To everyone joining us from Facebook, YouTube, and LinkedIn, thank you so much for being here. Whether you're a legal professional, a community advocate, or someone looking to understand this better, we're grateful to have you here. And if it is your first time with us, welcome. We are immigrationquestion.com, a two-in-one platform built with lead and case management features to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who use our platform. Also, with immigrationquestion.com, you can ask your immigration questions in any language and get connected with a licensed attorney for free legal guidance. And yes, just like many of our users, you can receive a free confidential initial consultation. Just visit www.immigrationquestion.com to learn more. And it gets better. We've just launched our new mobile app designed to make access even easier, whether you're a user or an attorney. Now, Attorney Velazquez, as someone who has many years of working with asylum, removal of defense, complex family-based immigration cases, what do you think about immigrationquestion.com and what it's doing for the immigration community and immigration attorneys like yourself?
Well, I personally am very grateful for what you're offering. The fact that it's accessible and free to many of our clients. Off air, we were discussing how sometimes we have phone calls from clients who simply need information. And the reality is that attorneys right now, immigration attorneys, particularly attorneys who do a lot of removal work like I do, we're a little bit overwhelmed. So we noticed we don't have the time to simply provide information consultations. We are trying to be more focused on actually representing people who may be detained and need to be released from detention, as we're discussing today. So having a platform like yours that I can refer to my clients, that they can review, get the answers that they need, has been extremely helpful. So I myself am very grateful for what you do, and I hope you continue doing it for many years to come because it's very helpful to our clients.
Thank you so much. We're glad that we bring such value to the community. Before we switch into the live Q&A session, we would like to say to someone watching today, what would you say to someone watching today who feels hopeless or frozen by fear because a loved one has been detained? Can they begin to move forward?
Definitely. So understand that, of course, for people who are out of detention, when a loved one is detained, you may feel hopeless, but we need to be proactive. And we need to also consider the person who is detained. Of course, they may want to be released, and they need somebody out. They need us to advocate for them, to take action right away. So it's absolutely understandable to have the despair and the hopelessness that happens when a loved one is detained. But the proactiveness is definitely needed, first to get out of that despair, to do something that can assist the person detained, and because they need it once they're in detention centers. So my first advice would be, don't despair right away. try to be proactive, try to take action, try to take the advice that we're giving today, locate the client's, the person's immigration records, find an attorney nearby, because making yourself available and being there for them is the main thing they need after detention. And understand that not all detention is fatal, that you may have, you are able to fight it, but you must be proactive.
Definitely. Thank you for that. We're now moving on to our live Q&A session. So if you've got a question for Attorney Velazquez, now's your moment. Drop your question in the chat or call us live at 516-703-3483. EAD through adjustment of status online account time says 3 months now and it's 5 months. Still no decision. Can I do an inquiry now or wait until the 6 months when it's officially outside of the process time?
So typically the processing time, a little tip, is there to avoid attorneys like myself suing the government for taking too long. They will say, oh, it's within the processing times and you have to take certain steps once beyond the processing times. But you can be proactive to get that answer that you deserve. Sadly, the 3 months is no longer the standard we've seen. It's more, a little bit more than 3 months. We're seeing from 6 to 9 months. So I'm sorry to be the bearer of bad news, but to put some pressure, I recommend if you try to do the status inquiry online and it's still within processing times, it will not allow you to move forward. It will tell you within the processing time, you have to wait until the processing time is over to submit it online. But understand that your receipt notice has a 1-800 number in the bottom. That number is rather annoying to call. When you call, you're going to be on hold for a while until you finally get an officer on the phone. And on the phone, they will tell you your case is within processing time, which is rather frustrating. However, every phone call that you make is recorded. So they will know, don't let this case slip through the cracks. Take care of it because this person's calling. We personally at our office call on a daily basis, sometimes on the same cases, and they will tell us, we told you the same thing yesterday. That's fine. I just want to make sure that it doesn't fall through the cracks. So you can be proactive, and although you technically have to wait online, make that phone call. Don't get frustrated with the answer. It's a good way to put pressure to make sure you get the work permit.
Definitely, thank you. And the next question that we have is, those who have SIJS status, I wonder if they're trying to ask, what is SIJS status?
Or maybe they're trying to ask what can be done with individuals who have this. So we call it CJIS, it's easier for us, and it's special immigrant juvenile status. These are individuals who enter the United States as minors and don't have a legal guardian, and they qualify for specific rules for asylum that actually make it a little bit easier for children to receive an asylum process because they don't have, once again, that parent, that legal guardian. So it's a different section of the law. What we've seen, sadly, is that the government has removed the legal representation, which was free in some cases, the free legal representation these children had. So we now have many NGOs and nonprofit groups trying to step in, and attorneys like myself who've been volunteering to assist with individuals who are trying to seek this CJIS status. For individuals who already have it, CJIS is the equivalent of asylum, so it works in a similar way. You can apply for your green card after you're approved the CJIS, after you're approved your asylum process. Now, if the time has passed, maybe you were a child, you didn't know you had to apply for a green card, you also have remedies to say, I was a child without representation, particularly under the current circumstances in which the attorneys are not available or the government is not paying for these attorneys. So you have some arguments to apply for that green card if you haven't done so already. These individuals should be protected from detention because they have an approved status. Individuals seeking it, though, that's why I gave the example of the government no longer paying for representation, because any child who's here without status, as a child, you don't accumulate unlawful presence, but you could still face detention at least for some time or be placed in removal proceedings. They should be protected, but they still may have to seek it.
All right, thank you. I hope that answered this person's question.
Yeah. Followed up.
Yeah, definitely. Another question we have is, I was stopped by ICE outside a courtroom after reporting domestic violence. Can they really do that? How can I protect myself legally next time?
What we're seeing right now from ICE, and I am so sorry this happened to you, but it is outrageous. In Florida, we haven't seen, for example, the violation of going into schools or churches, but that's because in Florida we had 27 churches that sued right away. But in many other places, like Sosa's explaining, We have seen detentions from hospitals and detentions even when individuals go seek the police report that normally you would need to file for your benefits for immigration. Even there, people are being detained. As to what you can do to protect yourself, what we are recommending, and once again, before up air, we were discussing things that I never thought I would say, but now I find myself warning. Of course, the police have mentioned that they're here to protect everyone and that you shouldn't have to worry about calling them. And that's where we see the difference. I am now advising my clients that while before it was maybe okay to go to a police station and report a crime, now it might be best to actually call the police station instead of showing up. And once again, I never thought I would say this. I never thought I would say that our leaders who are supposed to protect us are now actually putting us in danger. But sadly, we've noticed that ICE is being very aggressive in some jurisdictions, and places that before were safe haven, like hospitals, schools, churches, even the police stations themselves are no longer safe anymore. So it's best to call and report the crime than to show up. And I'm once again very sorry this happened to you.
Definitely. Next question is from, if ICE comes to my house, do I have to open the door or talk to them? What kind of warrant do they need to enter?
The answer is no. You don't have to open the door for anyone. The warrant that they need to enter to actually, for you to be forced to open the door, for them to knock down the door, it needs to be a judicial warrant. And I know it sounds redundant or basic that it's judicial, but this is a big deal when it comes to ICE warrants, because what we noticed is when a warrant is issued, it's issued by another deportation officer. That is not a judicial warrant, that it does not give them the authority to open the door, to get into your house. Sadly, ICE has been catching on to this, and what they tend to do now is approach the individuals outside of their home, already with knowledge that this individual is here without status, or we're placing this individual in removal proceedings for accusing them of whatever particular crime, or sometimes not even a crime, it's just whatever assumption the government may have against you. So understand that approaching outside, that is becoming a little bit more complicated, but inside your home, it's a judicial warrant. And the way you confirm it is when you look at the signature in the warrant that they may slide under your door for you to review, it should say if it's a judge or if it's a deportation officer. If it doesn't say it, assume it's not a judge, because it has to say if it's a judge, it has to be identified as such. And if it's not a judicial warrant, you don't have to open your door for anyone.
Definitely. Thank you. Next question is, I have a pending asylum application. Will that protect me from being detained if I showed up at my apartment?
Yes, it is essential that you carry with you evidence showing that your application is already submitted and pending. The best evidence that ICE is relying on is actually your work permit. Know that anyone who has an asylum pending for over 180 days can apply for that work permit. So if you are not there yet, at the very least, you should have received what we call the receipt notice, which is the confirmation from USCIS that your application was received. Have it with you. That should prevent a detention. Understand that should prevent a detention only for immigration purposes, because otherwise, if, for example, here in Florida, if you are caught driving without a license, maybe you haven't had a chance to renew it, which is being very difficult here because we don't have appointments to renew them. If you're pulled over for a minor crime, misdemeanor, such as driving without a license, you could face detention even if you have an asylum pending. So these are important details to keep in mind. There's a difference between being detained solely because of immigration purposes, or a detention that might be tied to something else, an encounter with the police that leads to immigration having access to you. So try to be very careful. Don't get arrested. But it's only ICE looking for status. You're here on lawful status because you have an asylum pending.
Definitely. Thank you. Next question is, I overstayed my tourist visa by a few days. Can I still apply for a green card, and how should I go about it? Or will ICE deport me first?
Entering the U.S. legally is one of the main requirements to be able to file for your green card application. Now, it is a big difference if you're filing for a green card application through employment or if you're filing for your green card application through family members, particularly immediate relatives. you're filing for employment and you have overstayed, you may be forgiven up to 6 months. If it's more than 6 months that you have overstayed your visa, you can still apply for your your residency application through employment, but you may have to finish the process through consular process, meaning outside of the United States, or you may have to seek a waiver through a family member here to justify staying in the U.S. because you overstayed your visa. This is very different from individuals who are seeking the residency through an immediate relative, which is typically a child over the age of 21 or your spouse who is a U.S. citizen. Any individual in that scenario can seek their green card no matter how long they've been without status. I'll give you my own example. My husband's from Argentina. He entered the United States legally and he stayed many years without status before he had the privilege of meeting me. So of course we got married and applied for his green card, although he had been here many years without status overstaying his visa because he had entered legally. Now, if it's another petition, maybe your spouse is a resident or it's a sibling petition, parent petition, then it may become an issue how long you've been without status. And once again, you may need a waiver or to pursue your green card through consular process. If ICE approaches you before you begin your residency process, you can still file for the residency process while you are what we call removal proceedings. But I do recommend if you have a green card and you're thinking about filing, even if you overstayed, file right away. Protect yourself. Filing for the green card can be considered, depending on the circumstances, the equivalent of the asylum that we mentioned before, meaning that you should be protected because you're here pending adjustment, which is a lawful status that will protect you from detention or deportation.
Definitely. Thank you. Next question is, I'm a lawful permanent resident, but I was detained at the airport during re-entry. Can they revoke my green card just like that?
No, they can stop you and detain you and place you in something called deferred inspection or even place you all the way in removal proceedings as a lawful permanent resident and coming in at the airport. By the way, anyone who's a lawful permanent resident and is placed in these proceedings at the airport would be considered an arriving alien. So that goes back to our issue with bond. You may not qualify for bond. However, the only person who has the authority to take away that green card after your entry at the airport will be a judge. So you will be placed in proceedings and you will have to appear before a judge, and the judge will have the final determination as to whether you keep your green card or not. So know that original detention and the placing in proceedings is not the taking away of your green card. It's the beginning of a process to potentially take it away in the future.
Definitely. All right. Our last question is, if I'm detained and can't afford a lawyer, what can I do? Is there any legal help available that won't cost money?
Yes, sadly, as I mentioned when we were speaking about sieges, the government has cut down on many free legal services that are available at detention centers, but we still have many nonprofits, NGOs, and volunteer attorneys like myself who go to many of these detention centers to provide legal assistance. Typically, they meet on specific days, so I encourage you, sadly, when we speak with our deportation officers, they might not give us this information. However, other detainees here become our best resource because they do, and feel free to ask them. Do you know if, for example, Catholic Charities is coming to this location? Do you know what specific days they meet? Because they typically have a specific day in which they'll meet with everyone and try to provide this legal assistance. Some judges are also, they're very cautious to warn you that they can't provide legal advice, but they do have to let you know your rights. So the judges will let you know what remedy you qualify for based on your answers at the preliminary hearings, which we call master hearings. They may tell you you qualify for asylum, you qualify for cancellation of removal, like we discussed before, and they will even give you the form you need to complete. My advice would be make many copies of that form before you complete them and follow the judge's instructions because the judge will tell you when you have to come back to court and file the paperwork. Also, speak with your friends and family outside because you'll need evidence, and that's the best way to represent yourself. Make sure you have all the evidence and follow the judge's instructions because they should guide you as to what to do in case you're detained.
Definitely. That was an incredible session. Thank you again for joining us, and a huge thank you to you, Attorney Vasquez, for your practical strategies and insights you've brought to today's discussion. We hope this conversation gave you clarity on what to do if detained by ICE. Don't forget, at immigrationquestion.com, you can ask your questions for free and get in touch with a licensed attorney who understands your case. You may also be eligible for a free initial confidential consultation. So head over to www.immigrationquestion.com to sign up today. And if you want to revisit this session or share it with a colleague, you can catch the replay on Spotify. Just search Borderless Talk by immigrationquestion.com. Lastly, for all immigration attorneys in New York City and surrounding areas, you are invited to join our in-person event in Long Island City on July 24th. Enjoy the company of like-minded professionals over food and drinks while learning how to scale your practice. Head over to our website to RSVP. Join us again on Wednesday for another enlightening conversation on a major immigration issue. Trust me, you won't want to miss it. Once again, thank you so much, Attorney Vasquez, for coming again, and we can't wait to have you back again.
Same here. Thank you.
Do you have an immigration question? Visit immigration.question.com, the easy way to get your immigration question answered from immigration attorneys. Free registration for users and immigration attorneys. And it's available now. For a limited time offer, visit immigration.question.com and get your immigration question answered. ImmigrationQuestion.com is not a law firm or affiliated with the USCIS. It's an interactive platform between users and immigration attorneys.